I hereby introduce to you Mr. Michael Veazey.
Hi, welcome to Amazing FBA. This is your host, Michael Veazey speaking, and this podcast episode is brought to you by Reliable Income, led by Adam Hudson. Reliable Income is an Amazon community and course, and Adam Hudson is an Amazon seller. He's doing well over 7 figures a year now, and also a very straightforward Australian. And in a sea of hype Americans, that is quite a refreshing change. Adam will tell you it straight when it comes to how much money you need to private label, which is measured in the thousands of dollars these days, not the hundreds, and how long it takes to really get a private label product off the ground when you're working alongside the day job, which again is measured in months rather than weeks. Now, alongside that, Adam, however, is a very, very positive guy, and he has a lot to offer in terms of getting a really great positioning on Amazon for your products. So high quality products selling at a really good price and keeping the competition at bay, which it's never been a smarter time to adopt that strategy than in 2018, when Me Too or Cheap are just going to be trashed by the Amazon crowd or have their price disappear into the floor overnight. So I really, really think his approach is sustainable. Hence, I think that Reliable Income is a very good word for his type of training. If you want to find out more about Adam, as I said, amazingfba.com/Adam. If you want to find out more about his training and or take the 4-part video training course, which is free, go to amazingfba.com/reliable, RELIABLE. Just for more transparency, I am an affiliate of that, so that will buy more than a coffee, as is the traditional affiliate sales. But what it will do is help cover some of the costs of running the podcast, which hopefully benefits you. Some of the software that I have to use to keep in touch with the guests, and my beloved and long-suffering editor, Daniel, who is worth his weight in gold, but I have got to pay him because even editors have to eat as well. So I've got to pay for blogging, podcast hosting, the rest of it. So that helps to cover some of my costs there. And I hope you'll check that out. Now on with the show. So ladies and gentlemen, welcome back to the show. Today we're talking with 2 legal young guns from the Amazon Seller Lawyers Office, or Amazon Sellers Lawyers Office, I think is how it's said. Anyway, it's CJ Rosenbaum's young legal guns who are there to help us as Amazon sellers. So we were talking with Rob Siegel last episode about the whole issue of basically creating intellectual property, what it is, and how you might go about protecting it, and the various levels of cost and complexity involved in that. Today we're talking to Travis Stockman, who is going to help the flip side of that equation. That is something that I guess as new sellers we all experience pretty frequently, or more frequently than we want, and is a bit scary, and that is the allegations that come against us that we're infringing somebody else's intellectual property. So Travis, first of all, welcome to the show. Tell us a little bit about yourself and your background.
So my name's Travis Stockman. I, as well as Rob, am in my last year of law school. Both of us sit for the bar exam this July. We'll be associates of Amazon Sellers Lawyers soon. I have almost 10 years of paralegal experience, one of the senior paralegals here. Everybody here has got a great interest in intellectual property. What I focus on is protecting the sellers, when they're receiving these intellectual property complaints on Amazon. So I do the opposite of what Rob does.
Great. Well, it's good to know that you, you can do whatever we need you to do, really, which I guess is what you want your lawyer to do. So, absolutely. So, the first question then is, what is the number one thing, indeed, that you find that people get accused of on Amazon, either by Amazon or by sellers, and what does that consist of from a legal perspective?
Often the majority of intellectual property complaints we receive are just general intellectual property. They don't specify copyright. They don't specify trademark. And often what these consist of is it's really an attempt to enforce a distribution agreement. Amazon, one of the unfortunate things is Amazon really prides itself in the consumer experience. So if there's even any infringement claim, they immediately send the complaint to the seller. They take it up, and it's your problem to resolve it with the rights owner that filed this complaint. Whether you're kicked off Amazon or suspended on your privileges, they don't care. They just want the problem resolved. They want their sellers to have the utmost. If there's even a consideration of IP, you're taken down before the problem can be vetted. On the opposite, instead, what they really should be doing is vetting these complaints before they're allowed to be filed. And then if that's the case, you can appeal it. Now, it makes it interesting because I see the majority of these actually don't have a basis for intellectual property, but are trying to enforce a distribution agreement, which is really what you see often. And it makes it challenging because then you have to go back and forth. Amazon has a strict policy. They don't enforce distribution agreements. The e-commerce, what I briefly said during Rob's segment, is how when you create this listing, you essentially grant the perpetual rights to use these images. You can use the description because you're just joining a pre-existing listing that the actual rights owner created. A lot of times this doesn't amount to intellectual property, but what the rights owner is trying to do is limit who can and cannot sell their product. But that doesn't come down to intellectual property, that's distribution. So we do help a lot of sellers who get these complaints. Often they'll receive a complaint. It just generally references intellectual property. And when we contact the rights owner, it turns out it's about distribution. Now, this is good because it gives us the ammunition we need, especially when we have the correspondence to show Amazon that this is purely distribution. We show this in appeal to Amazon's notice dispute team, that's usually reinstated right away. So that's always a good thing for us.
Okay, so this is a very, very key distinction. So what is allegedly, or what appears to be, or might even seem to be to a person selling stuff? Let's say that I own Mike's Marvelous Magic Mugs or whatever, Mike's Magic Mugs, let's call it that, right?
Sure.
And by the way, if you own this, I'm not claiming ownership. This is just an example. Yeah, don't come after me with your scary lawyers, guys, because I haven't got the money to pay for the legal bills right now. It's tax time in the UK. We've got to pay our individual tax at the end of this month. So I don't have the money, so I haven't got that out of the way. Legal disclaimer. If I own Mike's Magic Mugs and I want to be the only person selling on Amazon and somebody else starts selling on Amazon, I'm annoyed. And therefore, I think, right, I want that money to come to me, not to somebody else. So
Right.
I go to Amazon, I say, these guys are infringing my intellectual rights. I own the rights to all the intellectual property, the trademark, the design, whatever, on this mug. And really what I'm just complaining about isn't actually an intellectual property issue. It's a distribution issue. And therefore, I have no rights to complain about that. Is that essentially a layman's version of what you said?
Exactly. So long as there in the United States, there's what's called the first sale doctrine. And what this law states is that if you have this original product in the original packaging, non-opened, inclusive of everything that came with it, you do have the right to resell it. So when that's the case, that's one thing. There needs to be some sort of actual difference between the product that could support such a claim. Otherwise, it really is about distribution. What we've been seeing more and more is that sellers are including the fact that the warranty is not included with this product if you're not an authorized seller. What they're trying to do is create a substantial difference between the product now resold under the first sale doctrine and the product they sell, so they kind of have the authority to stop you from using it. But still, it's kind of a stretch.
Okay, so the first sale doctrine, and this is a really, really important point for everyone, including people on the other side of the fence as well, to understand that the first sale doctrine says you basically can't interfere, if I understand, with the constitutional right of somebody to resell a product as long as it's exactly the same as the thing you're claiming it to be. Is that a right understanding?
Right, and it has to be inclusive of the exact condition. It's got to be in the exact packaging. It's got to be from a legitimate source. Now, when I say legitimate source, often too, a lot of these guys are trying to enforce their distribution. Understandably, sellers, they still have the legal right to sell these products if they've purchased it from an authorized source, but they might not want to give this individual their distribution information because then they're just going to go and see who's selling it to them or find out how they're selling these products. But you can resell these products, and they're going to use it as a way to try and take advantage and enforce their brand. But if you provide Amazon with these invoices, show this is legitimate product, almost always they're going to reinstate the listing because they know within accordance with the first sale doctrine, you do have the right to resell these products.
Very interesting. Okay, so this goes against quite a lot of the experience that a lot of us have as sellers, which is, I've got a client at the moment that I'm working with who's just getting started on Amazon, and as a prelude to doing his own private label product is reselling other products in order to be able to gather the data about it, like the conversion rates, the sort of traffic, the impressions on ads and so forth, which is of commercial value to him. So he's just been sent something from somebody saying that he's not got the rights to distribute this product. And this is in the UK, not in the US. So it may be different, but let's assume it were in the US,
right?
For the sake of argument. What is his situation there? Does he have a legitimate claim against him, or could he just go back and say, I have the right to resell this, so go away?
Well, essentially, you said, you don't have the right to distribute this product. If that's solely the cause of the issue, then that's not going to constitute an intellectual property complaint. But, if like I was saying before, if there's some sort of discrepancy in the product, let's say this individual who sent the infringement claim states that their warranty or their quality controls are not inclusive if you're not an authorized seller, that starts to create a substantial difference, which could lead to an intellectual property claim. It still would have to be proven in the court of law or an arbitration with Amazon, but it would still have to be proven essentially. There need to be some sort of further basis.
Okay, so from a practical point of view,
sure,
please.
The problem that both of us see in what we do is that Amazon has no quote unquote gatekeeper who evaluates the basis of these IP complaints. So when Travis's clients receive them, or I submit IP complaints on behalf of my client, it's kind of a gamble of whether Amazon's going to properly evaluate it. So in Travis's situation, some of our clients will have received complaints on the Amazon platform, and because Amazon doesn't fully and properly evaluate them, and because we know from firsthand experience that the employees who are evaluating these claims are unqualified to do so, a lot of the times complaints that are baseless fall through the cracks. And that's where the advantage of having a law firm advocating for a seller becomes an advantage to have more of an investment rather than a cost.
Okay, that makes a lot of sense. Yeah, and it's part of that whole experience we all have as Amazon sellers that Seller Central has extremely variable quality, and it just is a bit of a lottery. So I guess that's part and parcel of the Amazon experience, and sadly extends to the legal side as well. So,
and just things to look out for. What actually, because I've discussed a lot what does not constitute infringement and what does. So just to settle that discrepancy, copyright. If we look at copyright, like I said before, the person who creates the listing, they've generated those images in accordance with Amazon policy, and that's a specific policy. It's slightly different from the law. They've granted everybody who joins that listing the right to use that image, to use that description. So it wouldn't constitute copyright infringement. But like I said, however, if you went and created a duplicate ASIN, your own ASIN, use that same image on your listing, use that same description, that point it becomes copyright infringement. Same thing like, you look at things like trademark infringement. Often what people don't realize, and there's a current case we're working on now, a lot of times they file for trademark infringement, but individuals who brand their own products are simply saying in the description that it's compatible for this product. It's compatible like a placemat for a Mike's Magic cup holder, or something like that, where they'll reference the actual trademark in it, but only for the purposes to show that it's compatible for. It's like a descriptive term. It's not actually branding their product or trying to advertise their product. So in those cases, it wouldn't constitute trademark infringement.
That's interesting. Now this brings us.
Sorry. A good example of that is with printer toners. A lot of the times, alternate brands from different countries will create compatible ink cartridges and toners that work with different brands of printers. And there's compatibility laws that allow the seller to use the word HP or Dell in their listing to describe that these products are compatible with HP or Dell products.
Interesting question. Now, that's something else that I've experienced personally, is that we had a big firm, and I'm not going to name them, obviously, but let's just say, imagine that I was selling Nike. Certainly, they're not actually Nike trainers. And I didn't say these are trainers by Nike, but I would use the keyword Nike in the back end. In other words, it's hidden from the public, but it appears in the listing, where the algorithm will see it. Now, I know that quite a lot of people get complaints or suspensions of the listings based on that. Is that, strictly speaking, an infringement of intellectual property rights? On the one hand, I didn't go to Nike and say, can I have your permission to use it? On the other hand, I'm not claiming that this product is by Nike.
Well, for what purpose would you be using the Nike in the algorithm?
Well, in order basically to get some ranking for people who are searching for the word Nike.
Right. And that would be that would probably fall under the category of advertising. That would probably be an infringement.
Okay. Well, that would explain why they took our listing down.
But if it's used to kind of promote their service, to promote their ASIN with their own branded product, then that would likely constitute infringement.
That's good to know.
The key difference is commercial versus descriptive use. So if you're using a trademark to try to boost your sales or increase your rankings on Google or the Amazon search results, that's going to likely be infringement. But if you're using to describe the way your product works or what it's compatible with, it's likely not infringement.
Right. So like an example, if you said shoelaces compatible with the Nike trainers, that would likely be okay. But if you said Nike or shoelaces - Nike or something, so it would lead to the confusion that this could be created by Nike, that's going to be trademark infringement.
Okay, interesting. So, I mean, one way from the seller's perspective, which is the one that I guess we're taking today, in terms of avoiding intellectual property claims as much as possible, or refuting them, is that we would say, okay, I'm going to put everything in descriptive type language. So we don't say Nike, Nike trainers, Nike, blah, blah, and just keyword stuff. We'd say something like compatible with Nike trainers, but we couldn't say something like this is very similar to X trainers, I suppose, because that would be trying to gain commercial advantage.
There, you even have to be cautious when using it just to show it's, you know, compatible with it, because if you start throwing in the term Nike too many times, you know, often enough that it looks like you're just trying to generate search results or use it for promotion of your product, then still they're not going to accept that.
But it's an interesting, I suppose, like a lot of these things, best business practice is a fine line between getting kicked off a platform or getting legal issues versus, you know, just being not aggressive enough. And I suppose it's like in sport. If you're playing tennis, you want the ball to land just inside the line, not just out, but not miles inside either. So I suppose it's a question of, in this case, you can use it as a descriptive use of it, which is not used too much. And then you can probably think that you should be in reasonably safe grounds. Is that a fair summary?
Yeah, and it also depends on the correlation between the products. You know, even if I'm going back on what I said earlier, if it's shoelaces, chances are shoelaces are compatible with every shoe. If you were just putting compatible with Nike, you know, like I said, it depends on the factors of the case. It might be an issue. But if it's something more specific, like, you know, if it says adapter wire compatible with a Sony something plasma TV, that might be more acceptable because people buying this adapter wire need to know that it's going to be compatible with this TV. There's almost a use for it. There's a reason that you need to put this in the description for the consumer. No, and I was going to say, and just be cautious to make clear, if you're going to do that in the description, that it's not a Sony product. It's just compatible with it.
Okay, yeah, that makes sense. So, I mean, if there is a specific or valid reason for mentioning a big name, then you can put it in. And I guess that could be part and parcel of the sort of niche selection process or the product selection process, because if you can legitimately link it to a big brand, but without getting the allegations that you're just linking for commercial reasons, but nevertheless, it's part of your strategy, and you can legitimately claim that it's linked for a sensible reason, I guess that's quite a smart sort of middle of the road strategy.
Right? Fall within the exception and would not constitute infringement for trademark purposes.
Excellent. Well, that's all very, very useful stuff, because I think that's very relevant for a lot of us selling products in a way we can use a little bit of very deftly done piggyback marketing, i.e. the brand, the billions that have gone into building the Nike brand or the Sony brand or whatever can give us a little bit of a benefit as long as we do it in the cautious way. Exactly. So tell us a little bit more about allegations of patent infringements or patent infringements, because obviously that's the kind of big guns that we all fear. It does happen. It happens more often than we'd like, unfortunately, because I've worked with enough clients now. I've seen a few people fall foul of those things. So what are the general big patterns or the most frequent things that you see, and what do we need to do about those?
Again, you know, it depends. If this is the brand owner who's created their listing, we're going to have to, you know, really do an assessment between the two patents. You know, you'd have to try and find the discrepancies between the two. For instance, like Rob said, if it's a utility patent and it's purely talking about the function, we're going to want to find things within this patent that show that the functionalities of this patent are different from his. It makes it a different product. And even still, you know, if there's similarities, those may still be protected, whereas you can only then in your patent claim the things that are different. Like Rob said before, it's kind of like monopoly, but not exactly. There's still room for creation and improvement. So if 4 of the claims on your patent, 2 of them are kind of almost identical to this patent, likely you're only going to be able to have a valid claim on the other 2. You know, it's the modification to the patent, but really that depends on the situation, and that requires like a detailed assessment of the 2 patents. More frequently, what we see with patent complaints on Amazon, which sellers have to be cautious of, is they'll join a listing and they didn't create this product. They're not the brand owner. They're just buying, let's say, some sort of device, and they're listing against this ASIN. Now, some sort of other patent right holder has a problem with this product, and they're really trying to get this patent rights across to the creator. But because everybody who's listed against it is also going to receive the same complaint, you know, you file against the ASIN, so everybody gets taken down. So a lot of times what I focus on is I hope to find like a reasonable brand owner who I'll say, you know, they're not the manufacturer of this product. They didn't create this listing. In accordance with all of Amazon's policy, they merely joined a pre-existing listing. If there is some sort of issue with the patent or something you want to take up, it really should be done with the rights owner. A lot of times they'll retract the complaint, but these require conditions. You know, they might want to see that this seller now starts selling their product as opposed to the one they were currently listed on. And that, again, it depends on every situation, the details involved.
Okay, so that makes a lot of sense for resellers. Let's imagine that you're, as a lot of people listening to this podcast, either will be or are planning to be or already doing. They go to China and they private label a product. Let's say they private label this coffee, this mug, and they put their own design on it here with their own sort of copyrighted, things and their own logo. And at the bottom it says Mike's Magic Mugs. This is not the greatest example, but it's just what I have to hand. So forgive me, guys. This isn't brilliant. And then somebody comes to me and says, this exact design of mug is copyrighted. You need to take this down.
Sure.
What happens at that point?
Are you talking copyright still or patent?
Sorry, I guess I'm getting muddled. I'm talking patent, I guess. If somebody says this particular shape of mug and this type
Right.
of
So like if you're
material,
talking about like the particular shape material, like let's say we're talking about a design patent, and
Yeah.
somebody's got a design patent where they're saying a 2.5 inch by 2.5 inch circular mug with a handle looped around the side, and they're the original patent holder for that design of the mug. And you're saying the brand owner is creating something that's like almost a complete replica, like it's visually the same. It's difficult. You're going to have to really break down into detail. Like, Rob was saying before, patent is a lot more complicated and there's a lot more steps involved. So like if it's the exact replica, there'll likely be an issue. That's going to be patent infringement. But if you can find some subtle discrepancies and things that are different about the design and what you're producing, for individuals, creating their own brands and self-branding these products and manufacturing their own goods, they should, it wouldn't hurt to do a little research first to see what other patents are owned for something of a similar design. And if possible, alter the design. Make sure there's something different about your design so it's not going to be an exact replication of somebody's else. Same thing with the functionality. If they're, developing the micro USB, just to use it as an example, and they're manufacturing a similar charging port, to like the micro USB, they'd have to make sure there's features in there that are significantly different. So there's always, you can't just go and create a complete replica and then sell it on the market, because if you get a patent infringement complaint, it's likely going to have a valid, plausible claim to it.
Okay, so one of the points you're making is to make sure that it's got substantial design differences from existing devices out there, or widgets, if you like, for want of a better word, so that any design patent infringement claims are going to just basically not be valid because it's not close enough.
Right. They just have to be cautious, make sure they're creating a different product.
Okay. So let's say, try and take a concrete example here. One sec.
Sure.
So I've got a couple of random objects here. So these are things on the desk here. So I've got a sort of circular, rather like a glass, might actually be a glass. I wonder what my fiance has been up to, holding a candle. And then we got a sort of frosted glass holder that's to hold the candle here. And then let's say we got one which has got a sort of little looped bit of metal around it here, so it looks a bit more like a sort of traditional lantern. Now,
sure.
Would those differences constitute enough of a design difference that if somebody with, say, the sort of frosted square-shaped glass came in, and this was a sort of circular type glass or sort of bowl-shaped, would that be enough of a difference?
A design patent claim from that candle holder to the one you were just holding on the other side, that would have no weight. Those are two completely different visual dynamics. There would have to be something very substantially similar for it to constitute.
Okay. So what about, so if they had the design, I mean, it's a bit unlikely in this case, I admit, but if they had the utility patent for a glass container designed to show, to contain a candle safely whilst spreading its light or whatever it was, then
sure.
that would be what's needed for them to really come after me for that, right?
Right. Well, now what Rob was going to before, what he was saying is about the functionality. If you notice, those two objects almost in a sense completely perform the same function. I don't think it would, correct me if I'm wrong, relate to something as simple as like that candle holder. They're too similar, but more or less something more complicated that has a similar function.
Well, in the case of the candle holder, I would say that if you had that general patent, yes, something that performs the same such as the candle holder, all are doing the same thing. However, depending on what is specifically claimed within the patent, there could be a reason that the votive with the handle on it is shaped with a lip that goes out like this, because it disperses light differently, which then becomes a functional difference, and you could arguably claim that the patent is not being infringed upon. So it really comes down to an analysis of what is claimed specifically in the patent itself, and then an analysis from that to see what the difference between the two products are.
Okay, great. Well, thank you for helping shed some light on that, and no pun intended. So let's come back to the Amazon sellers' experience of Amazon, which, as you both pointed out quite rightly, is pretty variable, and also that they don't really filter. Amazon does not really properly filter in any way. Sometimes filter, it seems, any sort of IP claims that come through their system. So, Travis, if I'm a seller and I'm selling one of these candle holder things, and I get an intellectual property allegation of, an infringement of property rights of some kind, and Amazon just takes the listing down and says, right, you need to sort this out.
Right.
What do I do next to get my listing back up in practical, simple?
So the first and most important thing, always contact the rights owner. Amazon's policy, like I said before, they kind of just take everybody out of the situation. You guys resolve this yourselves. And then once you've resolved it, come back and let us know that everything's been situated. So what happens is, first contact the rights owner. Even if you know it's a stretch, even if they're not responding, even if they tell you absolutely no, you at least can go to Amazon's appeal team and show them, we've done everything you've asked. We've tried to resolve this with the rights owner, but for the following reasons, this is our legal right to sell this product. But one thing, the first step is always most important, contact the rights owner. A lot of times the rights owner doesn't realize, and they understand Amazon can cast a wider net than they expect. And they might just want to go after the listing creator. They might be willing to remove the complaint from one of the guys who joined the listing, or whatever the case may be. So you never know. Contact the rights owner. It might be as simple as a phone call and email. But once you do contact this individual, you can either seek a retraction from them. And in the event they're non-compliant, in the event they're non-responsive, and non-responsive is something you definitely see often as well. You've at least got your ammunition to go to Amazon's appeals team. You could show them you've tried to use this, you've exhausted this remedy, and without Amazon's intervention, there is no resolving it with the rights owner.
Great. Well, that's really important to know, because I have had a client or two that I've worked with who has had this exact situation. They had somebody allege something, and then Amazon took their listing down, and the rights owner just did not respond whatsoever. And then they felt that they were in a stuck position. So, Rob, you were going to say something about that first.
Right, that's actually right along the lines of what I was going to jump in with. I just wanted to mention that it's also always important to make sure that whether you think the complaint is baseless or not, that you respond and take some sort of action. Because even though all complaints don't lead to suspensions, not addressing them can, and an abundance of complaints, whether or not they're baseless, can lead Amazon to suspend your account. So it's better to immediately deal with it, whether you think it has any virtue or not, to avoid any harm to yourself.
And I can't tell you how many times I've seen Amazon respond to sellers who come to us who have already submitted their own appeals and then have shown us the responses they've gotten. If you don't contact the rights owner, you're almost guaranteed a response from Amazon's notice dispute team that says, we cannot accept your plan as it doesn't address the issue at hand. Please resolve this with the rights owner and contact us once the rights owner is sent in a retraction. So immediately, if you submit a plan, there might be a chance of success, but it's small if you just send the invoices, your legal right to sell it. But it always, always helps to contact the rights owner first.
Great. Well, that's really, really clear guidance. Thank you very much for that. And you guys are in the position to really know what the average sellers do. And so it's very clear that obviously a lot of people aren't doing that. But let's assume then that I have tried desperately to contact the rights owner. I mean, first of all, one simple basic question: does Amazon provide some contact details for the rights owner?
Yes, they definitely provide contact details. Usually when you receive the complaint, only on a very rare occasion and only by Amazon error, when we've contacted Amazon, it's been rectified. Have they forgotten or maybe put in the incorrect email? But it's always going to have some sort of contact associated with the email that filed the complaint will show up. Occasionally also you'll see an individual's name associated with that email. And often what we found too is, like, let's say you have somebody who it says, mike.bestbyenforcement@gmail.com. And you're like, Best Buy has their own domain. They're bestbuy.com. Why would they have a Gmail account? It looks like it could be a fraudulent complaint. If they're not responding, you're reaching out, no response. What we do on occasion is contact Best Buy corporate, and we'll say, hey, listen, we received this intellectual property complaint for one of our clients. Could you confirm if in fact this email is associated or authorized by Best Buy? If so, we'd like to resolve this. If not, just send us some sort of confirmation. And you might get something from Best Buy that says, you know what, this person has no association with us. We didn't authorize this claim. And that in itself will be your appeal to Amazon, showing them that this didn't come from Best Buy. Whoever this is not the rights owner, and this claim is fraudulent.
Great. Well, that's really, really useful to know, because sometimes it does feel very much like that, especially when you get a Gmail address or something. Right. And again, I've seen that not with my own products, fortunately, so far, touch wood, but I have seen that with clients' products for sure.
Definitely. No, I was just going to say, if you're suspicious in any way, not getting responses, definitely be sure to contact the actual, the rights owner, whether it be Nike.com or a Sony website or something. Reach out to the actual corporate entities just to see what kind of response you can elicit.
That's a very, very smart and simple bit of advice, but that sounds very, very smart. So let's assume then that you've reached out, that it is a legitimate claim, and you reached out to people and they don't respond. So what do? You go back to Amazon and maybe do screenshots of the emails you've sent or something like that, just to show that you've made your efforts?
Of course, the first thing we're going to say, especially in the notice dispute letter, we like to, and we advise people that they put the first line of that notice dispute, whilst, just their name, who they are, the company they represent. The first thing you want to show them is, we have tried, as per Amazon's request, we've tried to resolve this with the rights owner. And usually what I'll do is say, see attached correspondence, where it shows all the emails or records of telephone calls and things that I've done to try and get in touch with them.
Okay, that's very, very good. So you want some kind of concrete evidence
showing that you've made that attempt.
Okay, so let's assume that you've done that and you send that stuff off to Amazon. What tends to happen next then, in your experience?
Well, to ensure the most success, also what goes into this appeal, we like to provide invoices. It's clear, and they try and enforce their distribution, so they'll request, show us where you're buying this source from. But, there's like certain things they're not looking into, and they have. So counterfeit, let's say they report an item for being counterfeit good or something along those lines. You need to perform a test buy to show that. You need to actually order the product. A lot of times they'll just say a basis. So what we do in the same letter is, even when we're contacting the rights owner, we demand a basis. And if they don't provide one, we show that to Amazon as well. We give Amazon the invoices to show that everything is legitimate. We're an authorized seller of these products. We show the fact that we've tried to contact this rights owner and that failed. And really that without Amazon's intervention, without their assistance, this can't be resolved.
Okay. And what tends to happen at that point then?
Usually, as long as you've bought your product from a legitimate source and it's, everything's okay, and we showed that you had the right to resell this within the accordance of the first sale doctrine, they'll reinstate the listing. Where resolving with the rights owner really comes into play and really is important is good because it gets a permanent solution. Sellers also have to be careful. We can appeal and they'll get the account reinstated. But now, they have to be cautious that this individual is not just going to make another enforcement email address or something and then submit another complaint. So like I said, the optimal situation, you always want to resolve it with the rights owner. And, then we do the notice dispute. We provide invoices. We show that we've made these attempts. It's usually reinstated. In the event, if what you're going to ask next is if that notice dispute fails, where we didn't hear back from the rights owner, we submitted an attempt to notice dispute, they reject our appeal for whatever reason, or notice dispute doesn't respond, what we do at that point is we contact Jeff Bezos's team. And Jeff Bezos has an escalation team. Now, you can't just go initially to Jeff Bezos's team. It's really only for if Amazon's lower teams have failed in some sort of way. A lot of times what we show is we've shown them we've tried to reach the rights owner. We've called Best Buy, who's confirmed this isn't, an associate of our company. We show that this person hasn't responded. And then the response we receive from Amazon is, your plan doesn't address the issue. Please contact the rights owner and let us know once you've received a retraction. Well, it's clear by that response they didn't actually read the appeal, or they didn't adequately sort through our appeal. So this is exactly what Jeff Bezos' team is there for. You can't start or initiate the appeal for his team, but what it is when his lower teams have failed in some sort of way, it's a combination appeal between showing why the lower teams failed in conjunction with the fact why you also had the legal right to sell this and have gone through all your remedies, contacted this individual and all that other stuff.
Okay, yeah, well, it's good to know there's a sort of escalation option. So now let's look at the scenario where you have contacted the rights owner and they've confirmed what they think their story is. What sort of scenarios happen from that point?
It really depends. If the seller is interested, and it's always a possibility, we'll see if maybe they can become an authorized seller for this individual. Usually what that entails, really they just want you to adhere to their, advertisement pricing, so that if they're selling their product, you're not just going to go and sell it for 40% less and take all their sales away. Mostly it comes down to things like that, just vetting that you're buying through them, adhering to their pricing. If that's something the seller is willing to do, and that's something they're willing to allow the seller to do, we'll look into options like that. Other times, even if there might be some, let's say there's a claim for infringement and it's truly 50-50. And if we brought this to the court of law, it could go either way. Sometimes we'll work out little arrangements or agreements. Well, they're allowed them to sell off the remaining inventory. But then once they do that, they remove the listing and we'll refrain from selling it going forward. And, there's all types of scenarios and agreements that we've worked out and can work out We have some sellers who, for them, if the product is not an issue, they'll just immediately, like we've had guys who they do a lot of high volume business, and upon receiving an intellectual property complaint, they immediately remove the product and won't relist it until they've resolved it with the rights owner. And not everybody can afford to do that, but it is helpful and it's respectful to the rights owner. They appreciate almost the fact that you've removed this product and are like willing to listen to what they have to say. Often in cases like that, if you take that kind of action, it makes it easier to negotiate. And these are like going back to what you said, when the claim is legitimate, when there's actually a plausible, assertion of infringement in any way.
Okay, so really helpful, some tips there on the negotiation process. So you're suggesting basically, if I understand, that you basically put your listing on ice, you delist for the moment before you talk to the rights owner, because that's more likely that they'll see that as a friendly act.
Exactly. And this is only in the event that this is a true and legitimate claim. If you're looking at it and you're like, I've created a duplicate listing, I've taken this guy's images, I've taken his description, and I'm listing this product, it'll be good to remove that product, contact this rights owner, let him know, this might have been a mistake. And I'll assure that I didn't realize this was a violation. I'll list on the correct ASIN going forward or something. There's usually something they want. Sometimes it's as simple, like I said before, if the products are different and they don't include the manufacturer warranty, often they won't file any IP complaints, but what they'll want you to do is change the listing description to like new original packaging, but does not include manufacturer warranty. Again, these are all it depends on the situation, it depends on the circumstance, the factors involved, but there are all sorts of outcomes that we've come to agreement with these rights owners.
Good. Well, it's good to know that in the Amazon world, there is such a thing as some sort of sensible negotiation at some point, as long as, I suppose, as somebody responds to you. And if they don't, it's good to know also that there is a mechanism for allowing Amazon to reinstate you or persuading them to, even if the rights owner just is not playing ball and not doing anything about it, which I think is quite a common situation from what I've seen. And I guess you will have seen all flavors of this, right, from your perspective.
Right. Absolutely.
So I think the most important thing, it seems to me, is to make sure that you're taking action as required by Amazon, and then you're basically keeping records. If I put it in two simple words, is the feedback that I'm getting. So, folks, we could probably talk for hours, because as soon as you get into more and more detail on specific cases, then obviously it gets incredibly detailed fast. But I think we've got some fantastic value from you both. So, Travis, thank you very much.
Not a problem.
All your input on protecting your own situation as a seller and a person dealing with allegations of intellectual property infringements, and also Rob for your episode on how to protect stuff that you've sweated blood to create. So guys, I think what I'm going to do is we're going to put the episode up probably under CJ's sort of space on the blog, which is getting quite full now. There's loads and loads of content for anyone who's looking at all sorts of things around suspensions as well as intellectual property issues. So we'll put it at amazingfba.com/CJ. I hope you guys don't mind. I was just thinking how to do this. But it's great to get another perspective, and from the younger generation as well, who have a different take on the internet and a different relationship with it. I suppose I'm sort of more CJ's generation, so it's a different take. Yeah, so I think don't say that too loudly. You got to work with this guy for a while. So I wish you both good luck with dealing with the horrendous bar exams and the things that are coming your way. I know from reading my John Grisham novels that sounds pretty grueling. Now that I don't know how true to life that is. But thank you both very, very much for coming on and giving us such helpful advice.
Our pleasure.